All right. Good morning, everyone. This is the staff attorney for Judge Krause. This is our civil calendar for Thursday, January 4th, 2024. I don't believe anyone has requested a court reporter. If there's a court reporter, please raise your hand on your monitor, but I don't expect one. We have a fairly short calendar this morning. 3 pretrial conference, I could actually take that back, probably at best 2 pretrial conferences. A motions hearing in the River Run Condo Association versus Patricia Irving matter, and then 2 petitions for review from Magistrate Court. That is the Natasha Ballard matter and the Jonah Addis versus Catamount Properties matter. Not sure what order the judge is going to take those in, but she will be asking for a time announcement, so I'll be ready to give that. I expect her to join us any moment here, as she is just next door to me, and I believe she's signing on soon. So hang tight, and I think we'll be underway in easily under 2 to 5 minutes.
Good morning. Before we get started, I did have a quick question. As I was logging in to this Zoom meeting, I received some sort of notification that said that the contents of this meeting were being sent to a third party. Is anyone sending this to some sort of third party, if you know? I'm going to follow up with our IT department to find out if this is some weird Zoom thing, but technically you don't have authority if anyone is actively doing that without permission from the court to do that. So if you are, please stop or let me know that that's something you were trying to do. I don't mean to imply that it's not legitimate. You just have to ask permission first. Anybody doing that? Okay, I'm getting a lot of blank stares, so I'm guessing that that's probably some weird thing that I need to follow up with IT on, but I did want to make sure. Yes, sir. You're muted, sir.
Scott, you're muted.
Yes, sir.
I'm seeing something on my screen that says YouTube.
Now that's a different message, and that's because this hearing is not being held in the courtroom. In order to satisfy the obligation of having open courts, this meeting is being live streamed to YouTube. So we're all now social media influencers. But that one I know about, and that one's something that we control. But the message I just saw was not one that I'd seen previously, and I wanted to bring it to everyone's attention. So with that, we'll go ahead and get started. Thank you for your patience. First position I have is JP Morgan Chase versus LaQuisha Sanders.
Morning, Your Honor. Shanika Collier for the plaintiff, and I believe Ms. Sanders is present. We have actually reached an agreement in this matter. I received an email from Ms. Sanders this morning stating that she's in the process of submitting an executed copy to our office so that it can be filed.
Okay.
She sent a photocopy, but I explained that we're gonna need like a PD, like a PDF copy.
Yes,
But
ma'am.
agreement was reached during mediation, and so that is the current status. As soon as we have the executed agreement, we'll be forwarded to the court for further review.
Okay, and Ms. Collier, I appreciate that announcement. And I think it was just one of those, we've had circumstances where parties announce settlement and y'all might have decided it was settled, but then it just sits on my docket forever and ever because nobody ever files an actual settlement, notice of settlement or an actual dismissal. And so the main thing I'll request, it sounds like y'all are in the process of having what you need to be able to do that. If you could just make a note to please, I'll probably make a note to follow up with you guys a week from today.
Yes, ma'am.
Just to have Mr. Freehoff reach out and make sure that we've either received a notice of settlement or a dismissal with the consent order filed. And assuming we get one of those, then we'll stop nagging you.
No worries, Your Honor. But again, Ms. Sanders, I believe she's going to send a copy today. So then hopefully we get that taken care of before the end of the week. So that's our
Excellent. Thank
intentions.
you. Thank you, Ms. Collier. And thank you, Ms. Sanders, for staying in touch and making sure that this matter got taken care of. And we'll look for that signed consent order as soon as we receive it. Okay.
Thank you, Your Honor. That concludes my business
Thank you.
report this morning. May I be
Yes, ma'am.
excused?
Yes. Thank you both. Have a good day. You may be excused.
Happy New Year.
You too.
Thank you. Bye.
Okay. Cisco Atlanta versus Elliott Hollander.
Emery Potter for the plaintiff, Your Honor.
Okay. Do I have anyone here on behalf of Elliott Hollander? Okay, Mr. Potter, it's only about 9:37, so I'm gonna give a few minutes. And while we're doing that, Mr. Freehoff, you can just let me know offline, but I'm gonna ask you to check on any, if we have any indication that someone on behalf of Elliott Hollander or Elliott Hollander got the notice, checked it. If we've been in touch with them in any way, you can just let me know
Your
Will
Honor.
do.
while we wait. But if you'll sit tight, Mr. Potter, I'm gonna go through the rest of the calendar and come back to that one.
Not a problem. Thank you, Your Honor.
Thank you, sir. Tough Yen versus Rick McDermott. I had a feeling this party might not appear because I think they're going to go to a bench trial. This is the one you were talking about, correct, Mr. Freehoff?
That is correct, Your Honor. They're having mediation mid-month and
Excellent. Thank you. Okay, River Run Condo Association versus Patricia Irving. I see Miss Sand and I see Miss Irving, I think.
Good morning, Your Honor.
Good morning.
Victoria Sand for the plaintiff. I'm going to actually ask if Ms. Irving and I and Scott, who is my client witness, can
Okay.
be placed in a breakout room to see if we can get this settled really quickly. She's been making payments.
Happy
on
to
the
accommodate
account
that.
since-
Yes, thank you, Miss
Thank
Sand.
you.
Happy to do that. Mr. Freehoff, can you please create a breakout room for Mr. Scott, Ms. Sand, and Ms. Irving? Ms. Irving, I don't know how familiar, and Mr. Scott, how familiar you are with Zoom, but what'll happen in a moment is that you'll get a message on your screen that says you've been invited to go to a breakout room. If you clicked on that, it'll take you and put you in a separate room where it's just the three of y'all having a conversation. Okay? And then y'all can come back and report to me if there was any resolution based on that.
Thank you, Your Honor.
Okay. And then I have Natasha Ballard versus D23 LLC.
I'm here. Thank you.
Your box is identified as V20. Are you, when you said I'm here, are you Natasha Ballard, ma'am?
This is Ada Apati for the respondent, D23
Hi,
LLC.
Ms. Akpati, how are you?
I'm fine, thank you, Your Honor.
Thank you. Again, the person who just spoke and said I'm here, is that Natasha Ballard? Uh-oh, I think we've lost that person.
okay. All right.
Mr. Freehoff, you're not muted. Okay, Ms. Akpati, if you can be patient with me for just a minute, I think the impression I got was that person was Natasha Ballard identifying themselves. So I'm going to give them a few minutes to see if they can rejoin the call. And then we'll go from there. If you don't mind, feel free to mute or, whatever while we wait. Okay.
Yes, Your Honor, I did want to say that we did want to request for, to see if we could reach a settlement?
Oh, and
With
so like a
Ms.
breakout
Ballard?
room so you could talk if
Yes.
she comes back?
Yes,
Happy
Your
to do
Honor.
that if we can get Miss Ballard. Looks like we maybe do have her back on the call. Miss
Hello,
Ballard,
Your Honor. This is
are
Dar
you there?
Jetty.
I'm sorry?
This is from Dar Jetty. It's D23, but I do have my counsel, Miss Ada, on the call as well.
This is Miss Ballard. I'm back. I was sent to a
Yeah,
breakout.
I think Mr. Freehoff created a breakout room and maybe everybody went to join it and it really should only just have been those three people. So I apologize for that. Ms. Ballard, Ms. Akpati and Mr. is it Jadapati? Is that
Yes,
correct?
ma'am. Yes, Your Honor.
Those individuals are here on behalf of D23 LLC, and they were asking if perhaps I could put you guys in a breakout room to discuss whether or not, just briefly discuss whether or not there might be some agreement that y'all could come to. Is that something you would be willing to do, Ms. Ballard?
No, not at this time.
Okay. Ms. Akpati? That's the announcement I've gotten. So can you tell me, Ms. Ballard, what I'm not going to call your case formally right now. Right now, what I'm looking for is how long do you think that it will take to present what you want to present to the court today?
To my understanding, has the court reviewed the affidavits that has been submitted?
Yes, ma'am, I have.
Okay, so what can I expect as far as procedure? How will this hearing go?
Well, so typically what will happen, because you are the movant, you're the person who's seeking relief. So I would call on you to make any presentation that you would want to make. Sometimes people choose to do that. Some people don't choose to do that. But the idea is that if you wanted to explain to me what your position is in some shorter or different way from how you put it in the filings that you made, and then I would call on Ms. Akpati on behalf of her client to make a response. And then typically, because you're the movant, I would let you have the last word. And then sometimes I rule during the hearing. Sometimes I take it under advisement. It just depends on the circumstances. But right now, at this part of the hearing, what I'm typically doing is just asking the parties to tell me, how long do you think it will take if you wanted to make a presentation to me, Ms. Ballard, or if you want to rest on your briefs, you can do that. But if you wanted to make a presentation to outline verbally for me what you believe are the important issues, how long would that take?
I'm not sure. To my understanding, with this hearing, I was under the understanding that the affidavits that have been presented are fully understood, and that based on what I have submitted, that there would be a proper decision and ruling.
Okay, so I'm interpreting that, Ms. Ballard, as you wanting to rest on the materials that you've sent, and that's perfectly fine. Ms. Akpati, what presentation, if any, did you intend to make? I'm just trying to get a time idea of how long this might take.
5 minutes, Your Honor.
Okay. Okay. I am going to continue calling my calendar and see who else I have here. And also, Ms. Sand, I see that you've rejoined us. Was there a problem with the breakout room or?
Yes, Your Honor. I think that I was put in a different breakout room than the other members of my
Well,
party.
the attorney is an important person to be in that breakout room. Mr. Freehoff, can you try to figure that one out, please?
Sorry about
Yes,
that.
I'll try to figure that out.
Okay. And while
That's
you're
fine.
doing that, I don't see anyone here on behalf of Jonah Addis versus Catamount Properties. And position 7 was resolved, the show cause hearing. Okay. So it looks like Mr. Freehoff, if you have, when you can, if you can also, I just saw your update regarding Elliot Hollander. If you could also review the file, position 6, Jonah Addis versus Catamount Properties. No one's here on that matter. And what I'm going to do is take about a 5-minute break, and then come back and take up the Ballard versus D23 matter, which seems to be the one that I'll need to spend more time with while others are attempting to resolve the case. Mr. Freehoff?
Yeah, that's fine.
Okay.
Okay.
I didn't know if you popped up to tell me something, so.
No, I just wanted to let you know I was listening.
Oh, okay. Thank you. I'll be back in about 5 minutes. Okay, I'm back. Ms. Ballard, Ms. Akpati. Thank you. Okay, so I'm ready to take up the matter of the Natasha Ballard versus D23 LLC, which is an appeal from a dispossessory order in magistrate court. Ms. Ballard, as I mentioned, I have reviewed the petition that you filed with the affidavit that was accompanied it. And so did you wish to make any oral presentation here at the hearing, or do you want me to rely on what you have submitted in your briefs, which again is fine. You may do whichever you wish.
Sure. So from my position, I filed an affidavit of priority interest in the property. I don't understand how we can be at this point when I'm not a tenant and there's no contract for being a tenant. The other party, the opposing party, says that they have interest in the property, saying that they have a sheriff's deed, which is what it's a color of title. It's not the title. There's no position of equity with that sheriff's deed. So to my understanding, with there not being a contract, and I'm challenging the jurisdiction of this other entity. I'm requesting that this motion under the titles, under the Rule 60V, this is thrown out. It just, we don't have a contract. There's nothing to really argue here. So, it's clearly displayed and stated in the affidavit that I submitted, and bottom line, we don't have a contract. The other entity does not own this property.
Okay.
I have priority interest and equity in this property.
Okay. Thank you, Ms. Ballard. As I said, I have had a chance to review the magistrate court file and the appeal materials that you filed in this case. One question I did have, Ms. Ballard, is that part of the order that was entered against you, which you are challenging here, right? That the magistrate judges, the purpose of this action is because the magistrate judge entered an order that said that you were not entitled to possession, and that and you're challenging that order. And I understand that part. But part of the order also requires that for you to challenge it, you're required to make some payment into the registry of the court. And my looking at the system, I don't see that any payments have been made. I think that that's part of Ms. Akpati's argument in a brief that she filed a couple of days ago, that you have not made a payment into the registry of the court to preserve your appeal rights. Can you tell me about that? If you have made a payment, and maybe I just don't have it in my system, or if you haven't made a payment, can you tell me the basis for that?
I have. They did not ask for rent. They didn't put an affidavit to ask for rent. So, and there's no contract, but I have paid into the court of registry. The paperwork is there.
Can you tell me how much you paid into the court registry?
All of it, it's on a continuous basis until this matter is resolved. The last month and the remaining balance, everything is in compliance with the order from Magistrate Judge Brooks.
Okay, I am going to call on Ms. Potty for her response right now, Ms. Ballard, and then as I said, because you're the movant on this matter, I'm gonna call on you and let you have a chance to respond, okay? Ms. Potty?
Your Honor, just to get straight to the point, no payment has been made. I did call the court this morning, and there has been no payment made. So if Ms. Ballard is saying that she has made the payment, could she provide to the court some form of evidence showing that she's made the payment? Because again, as of 15 minutes ago, no payment has been made, or the court is not aware of any payment being made.
Yeah, I have looked in both the magistrate court file, which is often where those payments will go. And I've looked in this action. And the financial documents don't indicate that any payment has been made in either case. Other than the original, I think, $103 filing fee that was paid by the defendant in the magistrate court. Excuse me, by the defendant D23, the filing fee. Ms. Ballard, do you have any documentation? I'm looking at the file and I don't see anything that indicates payment. I'm happy to follow up with the court because sometimes the clerk gets a little bit behind, but do you have any documentation regarding when you made those payments or the amount of the payment?
It was a couple weeks ago when I filed it into the court of registry.
Okay, what did you file? Did you file like a proof of payment or what did you file?
It is basically a money order.
I apologize. I need to take a brief break for something. Hold on just one moment. Okay, Ms. Akpati and Ms. Ballard, I apologize for that brief interruption. Okay, so where we are right now procedurally is that there is a dispossessory order that was entered by Judge Brooks on December the 7th that awarded a money judgment in the amount of $459.40 to Ms. Akpati's client, D23, and then also ordered that any rent amount in the amount of $998.11 had to be paid on the 5th of each month, beginning, let's see, with January the 5th. But that would have required a prior payment in December. And there's no, respectfully, Ms. Ballard, I don't, if you can provide me with some documentation of the payment, I'm happy to pursue that with the clerk of court and find out if there is some issue with it being credited to the wrong file or something like that. But absent any such documentation, there's no evidence that the required payment has been made either into the magistrate court or into the superior court file. And absent that payment being made, the order that was entered very clearly says that if tenant appeals the judgment and wishes to remain in possession of the property, those payments must be made. And so that would typically mean that the dispossessory order would be issued in Stanter, and D23 LLC would be entitled to possession of the property in Stanter, which would mean immediately. Do you have any additional documentation that you could perhaps email to Mr. Freehoff and copy Ms. Akpati on so that I could see it and then follow up with the clerk regarding what happened to a payment that you made?
So I tendered a payment into the Court of Registry. If my payment was not accepted, I would not have received a case number for this case right now. The payment was accepted. It had to have been in order to get this case number.
Well,
So
actually,
I have to feel that.
Actually, that's not correct. So the file indicates, Ms. Ballard, the file indicates that you submitted an affidavit of poverty and that poverty affidavit was granted for the filing fee. So you didn't have to pay a filing fee to be able to open this case.
Respectfully, I
Yes,
tendered a payment in the magistrate court.
Right. And
Otherwise,
I'm not questioning, Ms. Ballard, that you did. What I'm saying is I need some documentation of that payment because there's no such payment reflected in the magistrate court. And so if you have a receipt, if you have a copy of the money order, if you have even a bank transaction indicating where you withdrew that money from, or where you obtained the money order, that would be some information that I could then go to the clerk and say, hey, I've got a party telling me that they made a payment and there's no record of it. Can you help me find this payment and why there's no record of it?
according to law, I tendered the payment, and I don't know if there's some type of mix up between both courts, but I filed it in both courts. The tender payment is there respectfully. Otherwise, I would not have been able, they even said this has to be satisfied in order to get a new case number for this appeal.
Ms. Ballard, I understand that. All I'm asking is, can you tell me what was the amount? When was the payment? Where did you get the money order from? That's the type of information that I would then be able to go to the clerk and confirm that information. And then they might be able to track the payment and figure out where it went if you made the payment.
All right, can you hold one moment while I get the information? Thank you kindly.
Okay, Ms. Akpati, I'm gonna put a pause on this for a moment while I go back because I see that another party has joined us. Ms. Sand, were you able to reach any agreement with Ms. Irving?
Yes, Your Honor. I believe we have reached an agreement in principle. We've agreed on the total amount. She just wants to look over the numbers and propose a payment plan. So
Okay.
if we could be continued off this calendar, I will send her over the information immediately after the hearing. And if you could give us about 2 weeks to get the paperwork in, we will be submitting a consent judgment to the court.
Okay, that should be easy enough. We typically have a calendar late in the month, each month, to
Okay.
sort of grab anything that's going to be resolved during that month. I suspect it would be sometime the week of the 22nd.
Perfect.
And so what we would do, Mr. Freehoff would send you notice. It'll be placed on the calendar, but if y'all resolve the case, then obviously, Ms. Sand, you appear in front of me enough to know. We will happily remove you from the calendar as soon as you send us that consent order, letting us know that it's been resolved.
We will do so.
It'll be January 30th.
Oh, okay.
Okay,
So that
perfect.
next week then. Okay. So I'll make a note that it will be reset for January the 30th. And I will hopefully expect to receive a consent order from the parties resolving that matter. Ms. Sand and Ms. Irving and Mr. Scott, thank you for working through that and coming to a resolution. And I will look for the order resolving that case from everybody. All of you may be excused. Thank you for your time.
Thank you, Your Honor. Happy
Have
New
a good
Year.
day. Happy New Year. And Mr. Potter, are you there?
Yes, Your Honor.
Mr. Potter, I have waited almost 40 minutes. No one has appeared. Mr. Freehoff's review of the file indicates that confirms that the email address that Mr. Hollander has on file with Georgia e-file is the same email address that he personally provided in the answer that he filed. And despite that, there's no indication in our system that Mr. Hollander ever opened the notice of hearing or the pretrial conference notice. And so that would mean that Mr. Hollander has failed to appear. What relief, if any, would you like to ask for on behalf of your client, Mr. Potter?
I would also like to point out that yesterday we all corresponded with Mr. Freehoff and Mr. Hollander, though he never responded, about the hearing today, confirming the time. So at this point, I would like to make a motion to strike the defendant's answer and enter judgment.
Forgive me for not knowing off the top of my head, Mr. Potter, but is the amount of your judgment, would it be fully liquidated or are there unliquidated aspects of the petition?
The damages are liquidated.
Okay.
It is a invoice and statement of account case.
Are there attorney's fees though?
The attorney's fees are, but they are under 13-111 and so
Okay.
13-611, so they do not require any proof.
Excellent.
Of the math. And I have supplied everything to you in the complaint. I can supply an order, or if the court wants to do that.
And that's what I was going to ask. So I agree, Mr. Potter, that the answer is due, the answer of Elliot Hollander is due to be struck, given that this was noticed properly as a peremptory calendar with notice that the potential ramifications of failure to appear. This is also, a pretrial calendar, and that as a result, striking Hollander's answer is the appropriate remedy, which I will do. Having struck Hollander's answer, it would appear that Hollander is therefore in default. And since Cisco, since the damages sought by Cisco are fully liquidated, including the attorney's fees that are recoverable under 13-111 and not 13-611, I would be willing to grant a default judgment. If you could please, Mr. Potter, provide a proposed default judgment to Mr. Freehoff. We will take care of the order that says the failure to appear resulted in the striking of the answer. But if you could provide us with a proposed default judgment with the recitation of your damages, we would, we'll go ahead and review that and get it on file for you.
All right, Your Honor, I'll have that to him in about 5 minutes.
Thank you, Mr. Potter. I appreciate it.
All right, have a great day.
You too. Bye-bye.
I'm back.
Excellent. Very good timing. Ms. Ballard, were you able to locate some materials regarding that matter?
Yes, so let me just turn on my camera real quick. 1 moment. Kind of weird. Okay,
Yes,
so
ma'am.
I filed a notice of tender payment into the courts, and yeah, so to settle this account, I did file tender payment to the courts, and I'm sure you can see the affidavit in there. and it has proper endorsement. It's been properly endorsed. And if you like, I mean, I
Ms.
can-
Ballard, can you tell me the case number on that? Is it this case number 2023 CV 390-111, or is it the 23 ED 284-322 case number?
It's 23 ED 284-322.
Okay. Give me a moment to look in the file and see what I can locate. Okay, give me just a second.
Thank you.
Yes, Mr. Freehoff.
Judge, I just wanted to, I'll come talk to you.
Okay. Okay. Thank you for your patience as I've sort of worked through this. Ms. Ballard, Ms. Akpati. I was able to locate the filing that I think that Ms. Ballard was referencing, which is a notice of tender of payment to settle and close account.
Yes.
And is that the thing you were referencing, Ms. Ballard?
Yes. Yes.
Okay, it was filed in the magistrate court on December the 12th.
Yes, that is correct.
Okay. My review of the notice that you filed. So first of all, I've spoken with the clerk of court, and they have no record of any payment. They have looked everywhere they can think of, including associated with your name, associated with this case, associated with the Superior Court case, and they can find no record of payment. But more importantly, Ms. Ballard, my review of your filing seems to indicate that you are rejecting the acknowledgement that there is that money would be any like it doesn't appear that you actually submitted legal tender of any sort to pay or satisfy this. You instead submitted some sort of signed, some sort of authorized representative document, but no money order, no check, which I don't think they take, no cash, no certified check, anything like that. Is that an accurate statement? Am I correctly understanding what you filed, Ms. Ballard?
I filed a tender payment, and it didn't, I mean, the law says that I can tender a payment. It never stated how to pay it. So, I mean, I fulfilled the contract based on the order. I mean.
Ms. Akpati, other than the motion that you filed regarding the lack of payment and your statements here that there has not been a payment, what is your position on behalf of your client on this matter?
Our position is that this matter should be dismissed. Ms. Ballard has to comply with the order of the court before filing this appeal.
Okay. Ms. Ballard, I I understand. I find, first of all, thank you for helping me understand what it was you filed, because originally when you were saying a money order or something like that, I was looking and I was not finding. And so I have reviewed what you filed now that I understand what I was supposed to be looking at. And, you know, due respect, ma'am, but it is not filing a paper that says I hereby tender payment that is not actually accompanied by a payment recognizable in legal acceptable tender in the United States, then you have not made a payment under any legal definition that I am aware of. And so as a result of that,
What
you-
species?
excuse me, Ms.
what
Ballard,
species
I'm
of
speaking,
payment?
and in a moment, I'll let you respond if you would like, but you have to let me finish
Sure.
speaking.
Thank you.
So as I was saying, the motion, I think, is to dismiss the appeal of the dispossessory and to issue a dispossessory affidavit in Stanter, which would seem to be appropriate here because there's been no payment made. And in the absence of a payment, there can be no appeal. And that is the position that D23 is taking. Would you like to respond to that before I rule, Ms. Ballard?
Yes. So, I mean, on the order, it did not specify how to pay. What species of payment is on there to pay? It was not specific.
I'm sorry, are you saying it wasn't specific in amount or it wasn't specific in method?
In method, yes.
Okay. I disagree. This is a standard order, and the vast majority of everyone I've ever dealt with that deals with these orders understands that when it says tenant must, in capital letters, make the following payments into the court registry by the time specified, everyone understands that I've typically dealt with that means money that is recognizable as legal tender in the United States, which would either be cash or a money order or a certified check. And in the absence of those things being paid, then the court wouldn't have any choice but to dismiss the appeal. And so
I gave you a bill of exchange, which is the same thing.
I'm sorry, ma'am?
I gave you a bill of exchange, which is the same thing.
No, ma'am, it's not. A bill of exchange is not recognized as legal tender in the United States, and therefore it would not satisfy the requirement that tenant must make the following payment into the court registry.
Will you be so kind to confirm under what law?
For that reason, I am dismissing case number.
I mean, ma'am, I object. I object. I mean, it's there. Under what law does it say that it is not a legal payment, a legal tender?
So, in all honesty, I don't know the answer. I could do some research and find the answer, but Ms. Ballard, it's your obligation as the movant to provide the information that the court requires in order to understand your case, to accept your case. And you have not provided me, more importantly, with any documentation or a legal citation that would provide me with some sort of basis to accept your providing me with this note of exchange as legal tender. As I said, my understanding of the law is that a note of exchange is not legal tender recognized in the United States, and therefore it does not constitute a payment.
You have not provided me an answer, but under what law?
Yes, ma'am, I did. The answer I gave you was that it was your obligation. Mr. Freehoff, please mute Ms.
I need
Ballard
to
if
finish
she's going
what
to
I
continue to
have to
speak over me.
say.
Mr. Freehoff, please mute Ms. Ballard if she's going to continue to speak over me. Thank you. Ms. Ballard, you've been muted because you continue to speak over me, which is disrespectful to the court.
I'm not trying to be respectful. You're
Ms. Ballard,
me and not properly.
you are continuing to speak, and Ms. Ballard, stop. I understand that you do not like the outcome. I understand that you believe that that legal tender or notice of exchange that you gave me should count, but it does not. The answer to this question is that the order that was entered says that tenant must make the following payments into the court registry, and there were no payments made into the court registry, and the filing that you submitted does not constitute a payment of legal tender into the court registry and does not constitute compliance with the order that you make a payment into the court registry. And therefore, the case is going to be dismissed. case number 2023 CV 390111 will be dismissed for lack of payment. Anything else that the parties need? Ms. Ballard, you may pursue whatever appellate rights you wish to pursue.
You cannot
If
make a
obviously you
ruling over
disagree with
something
my
that
order.
you don't know.
I'm sorry, Ms. Ballard.
You
I
cannot make a
did not hear
ruling
you.
over something you can't know. You saying you don't know is an unacceptable response, respectfully.
Ms. Ballard, as I said, my answer was, if you would like to direct me to case law that says that what you
Is this a
submitted
court of
is
law?
legal, Ms. Ballard.
Is this a court of law? It is unacceptable for you.
This matter is adjourned. Ms. Ballard, you may pursue whatever appellate remedies you would
Keep
like to
muting
pursue.
me, and we're going to have
This
another
matter
hearing
is
in person
resolved.
because you guys are very
Thank you, Your
disrespectful
Honor.
and not
Thank you,
upholding
Ms.